In this video, I'll take a look at a 4th century BCE Athenian speech known as Against Kallipos. This speech is really interesting to me because it provides an insight into classical Athenian bookkeeping practices. But more so, because I'm going to explore whether the recorded transactions are evidence of the transfer of the benefit of a debt. If this is the case, then that would be significant because the same basic legal mechanism is what underlies debt securities, checks, and other negotiable instruments of the kinds that scholars claim never existed at the time. This speech also features pirates, so it's got that going for it too. Welcome to Ancient Classics. The speech known as Against Kallipos has come down to us as part of the Demosthenic corpus. It is conventionally known as Demosthenes' 52nd speech, but it was more likely written by the man who delivered it, Apollodoros, son of the famous Athenian banker Phocion. It is a law court speech in respect of Apollodorus' litigation with a man called Kallipos. Apollodoros tells us how his father, Phocion, had a client, a man from Heraclea called Lykon. Lykon was about to set sail for Libya, so he went to Phacion's bank in Athens to deposit some money, totaling 16 minae and 40 drachmae. Lykon arrived at Phacion's place along with 2 pals, Alcibiades and Phrasios. Lykon told Phocion to pay the deposit on demand to a man called Kallipos. Phocion did not know this Kallipos chap, so Lykon told him that Alcibiades and Phrasios would be able to verify Kallipos' identity for Phocion when he came for payment. All this was written down in Phacion's books, according to what Apollodoros explains is standard accounting practice. By his account, when recording a deposit, bankers would write the name of a third-party payee, Kallipos in this case, alongside the deposit entry. The verb used is paragraphein. When the payee is unknown to the banker, then the names of those who would verify the identity of the payee would be written next to that marginal comment. Prosparagraphein. Let's assume that Apollodoros' summary of this supposedly common practice is correct. How would one characterize the fact that deposits are payable on demand to a named third party from a legal perspective? The first thing to consider upon which everything else turns is what is the nature of a deposit. There are broadly 2 likely outcomes. Either by placing a deposit of cash with the banker, the depositor client is asking the banker to take care of or to safeguard those coins which remain the property of the depositor. Or alternatively, by placing a depositor is making a loan to the banker, giving rise to a repayment obligation, a debt owed by the banker to the depositor, which is how deposit taking functions today. I considered these things in a video a few years back, and I feel it is more likely that a deposit was a loan repayable by the banker to the depositor. So let's run with that model. In that case, where a depositor such as Lykon asks a banker to pay the deposit on demand to a third-party payee, here Kallipos, then that could mean one of several things. The first possibility is that the depositor, Lykon, has assigned or otherwise transferred the benefit of the deposit repayment obligation to Kallipos, so Kallipos becomes the creditor to whom payment is due. A second possibility would be that the third-party payee is merely acting as some kind of agent to receive the deposit repayment on the depositor's behalf, who remains the creditor. A third possibility would be that the payment by the deposit taker, Phocion, to the third-party payee, here Kallipos, might in fact be a telescoped version of a payment flow whereby the depositor repays the deposit to the depositor, Lykon, who in turn pays the money, whether by right of a gift or loan, to the payee, Kallipos, with the deposit taker, Phocion, acting in effect as the depositor's agent in making that final payment. In this case, the depositor remains technically the creditor from the banker's perspective. A fourth possibility might be that the depositor, Lykon, owed the payee, Kallipos, some money already, and so by asking the deposit taker, Phocion, to pay Kallipos, the depositor, Lykon, is effectively paying off his own debt to Kallipos by assigning the right to repayment of the deposit in which case Kefisiades becomes the creditor from the bank's perspective too. And the fifth and probably final alternative is similar to the fourth in that it could be that Lykon owed money to Kefisiades, but his debt would be discharged by way of a payment to Kefisiades by the banker Passion of the deposit owed to Lykon. This variant is effectively a combination of the third and fourth, but from the banker's perspective, Lykon remains the creditor, albeit that the deposit repayment obligation is discharged by paying a third party, with the bank effectively acting as agent for Lykon in making such payment. There are probably other alternative analyses, but I'll leave it at that. Now, we must be under no illusion here. Not only might it be next to impossible for us to ascertain which was the right answer today with our imperfect evidence available, the answer might not even have been known or clear to the parties at the relevant time, if they'd even thought about it. So, Lykon, the depositor, that is, went on his little sailing trip to Libya. But on the way he got attacked by pirates, shot and eventually died. Enter Kallipos, an Athenian who rocks up at Pasion's bank. He proclaims himself to be a proxenos, some kind of representative of the people of Heraclea, Lykon's hometown. He demands to see the bank's books and the record of the deposit made by Lykon. Pasion's assistant Phormeion shows Kallippos the books, and according to Apollodoros, shows how the deposit is expressed to be payable to Kefisiades. Next, Kefisiades himself turns up with the two witnesses to seek payment of the deposit. Later, Kallipos reappears and approaches Pasion. He inquires whether Kefisiades had shown up and explains that Lykon had no heirs when he died, so all his wealth went to the people of Heraclea. As their representative, Kallipos is therefore responsible for collecting all of Lykon's assets. So he's hinting that Pasion should pay the deposit to him, not Kefisiades. Pasion doesn't quite give him a straight answer. But several years later, after learning that the deposit had been paid to Kefisiades, Kallipos sues Pasion, who by this stage is frail and ill. The ailing Pasion and Kallipos take the matter to arbitration, and the dispute is never fully resolved before Pasion's death. Kallipos therefore subsequently sues Apollodoros as Pasion's son and heir. Now, Apollodoros claims that he was prepared to swear that Pasion had never promised to pay the deposit to Kallipos, and that moreover Kallipos had been aware all along that the books showed that the deposit was payable to Kefisiades. Apollodoros then proceeds to challenge Kallipos' standing and his right to claim payment of Lykon's deposit. Apollodoros refers to some claim by Kallipos that Lykon had gifted or owed money to him, which doesn't quite seem consistent with Kallipos' assertion that his claim derived from his role as the representative of the people of Heraclea. Moreover, as Apollodoros notes, if Lykon owed or had gifted the deposit to Kallipos, why wouldn't he have left the money with him, not Pasion? So what conclusions can we draw about the nature of the arrangement whereby Lykon deposited money and ordered for it to be paid to Kefisiades, i.e. these 5 options? We don't know the outcome of the case, but the following points seem fairly clear to me. First, I suspect that the basic assertion that the deposit was stated to be payable to a third party, Kefisiades, was at least superficially true. Second, all the payment flows took place in Pasion's lifetime under his or his assistant Phormeion's watch. Pasion and Phormeion were both experienced and more than competent bankers. Related to this is, third, I find it hard to believe that Pasion and Phormeion would have agreed to pay the deposit to a third party unless they were comfortable that to do so would not expose them to undue risks of third-party claims. Fourth, I doubt that Pasion or Phormeion were negligent or just confused. The description of ostensibly commonplace bookkeeping practices and the well-thought-out means by which Kefisiades' identity was to be verified by the 2 known witnesses is indicative of a sophisticated, well-tested market practice, one executed with intentionality by the parties concerned. Now, none of this leads to any firm conclusion as to the nature of the arrangement between Lykon and Kefisiades, and crucially, whether Lykon had transferred the right to receive payment of the deposit to Kefisiades, or whether the latter was merely acting as his agent. But if it is the former, and that Kefisiades actually became the creditor in effect of the deposit, then we have more compelling evidence of debt transfers in classical Athens other than through an inherited estate. That would be significant significant because that same basic legal mechanism is what underlies cheques, debt securities, and other negotiable instruments of the kinds that scholars claim never existed in classical Athens. We're getting into the realms of speculation here, so I don't want to get too much into it here. But a transferable deposit, which is what we seem likely to have here, is legally not too dissimilar from a transferable debt security or a bond. See, all a bond is really is the acknowledgement that the subscriber for the bond has, like a depositor, made a loan to the securities issuer or deposit-taking bank. Bonds really come into their own where they are transferable, i.e. the subscriber to the original bond can sell the bond to a third party who then becomes entitled to interest and principal payments, which from a legal perspective is almost the same thing as Kallipos being given the right to repayment of the deposit. In fact, bonds and deposits are so similar that under modern UK financial regulation, a specific technical exemption is required to ensure that bond issuers are not deemed to be deposit takers. What I'm saying, in other words, is that though there are, to my knowledge, no examples of the issuance of classic debt securities in classical Athens, the legal concepts underpinning bonds and other transferable debt securities may well have been in place by the 4th century. And to me, that's crazy. But what's your take? Of these 5 options, which best fits for you? Anyway, like and subscribe and we'll be back soon.
In the depths of the ledger, where trust meets deceitful schemes, count the cost of your pressure as the balance slips from dreams. Watch the scales slowly teeter on a knife edge of fate's decree. Feel the weight of the future while the echoes of death decree. Again on Athens with wisdom carved in stone, in the shadows of fortunes where the seeds of greed are sown. Every risk that you wager is a gamble on borrowed time. In the heart of the theater, every loss a tragic rhyme. Shake the foundations of power, hold the reins of monetary faith. With a clash and a crystal hour, step on stage, don't hesitate. Again on Athens with wisdom carved in stone, in the shadows of fortunes where the seeds of greed are sown. Scars can fray like old parchment. In the light, let truth reside. Riding waves of investment, with a song we'll turn the